All right. What's up? What's up, witches? Welcome, welcome, welcome to the weekly refuel session. Our weekly refuel sessions are our group coaching sessions that go down in the bunker, my virtual private space for witchpreneurs. This is our stronghold. This is our safe space. We have discussions, we share stories, we connect with each other, we exchange resources, and we learn. You can find the links to get into the bunker and to join us down in the description. Let me see what I want to see here. Here we go. Bam. And if you don't know who I am Ali Kravitz, aka the Bronx Witch. I am the founder of Witchwork, the Bronx's only co-working space for spiritual practitioners, and I'm the CEO of BetterWitch Coaching. I offer classes and coaches to witches that want to get better, and I teach on topics related to spirituality, magic, and spiritual entrepreneurship. And today we are continuing on in our discussion of business formation. We talked all about how to actually legally form your business in our last refuel session. We talked about LLCs, EINs, bank accounts, and all of that good stuff. So definitely go back to the previous videos that I have posted where I have shared that information if you are wondering how you as a spiritual practitioner should go about forming your business. But today we are going to be moving on into protecting our business and protecting our creations. And specifically, we're talking about intellectual property and intellectual protections. What do you actually own? What actually belongs to you? Because there's a really good chance that a lot of the things that you think are yours are not actually yours, in the sense that they're not protected from somebody else copying them, ripping them off, coming up with their own version, reposting them somewhere, etc. And there are steps that you can take in order to protect yourself and your business. And as spiritual practitioners, these are some of the types of things that we tend to not think about that often. We definitely forget about that. But things like your logo, your business name, your social media handles, your favorite taglines, none of these things are necessarily yours. There are steps that you're going to want to take to make sure that you have protected yourself from somebody else going and copying them, etc. And we're going to talk about that a little bit today. I want to also let you know that if you're feeling overwhelmed or you're confused about, like, how do I do this? How do I get my business going? What are the exact steps that I need to take as a spiritual practitioner? There's thousands of pieces of information on the internet and they don't all seem relevant to me. I want to let you know that I created a business checklist specifically for us. And it gives you literally bullet points on how to form, manage, protect, promote, and scale your business. Okay. This is a free checklist that you can download. It's available in my class portal. And if you're watching this on YouTube, I will link it in the comments so that you can download it for yourself and literally just go through and check everything off. Make sure that you've got everything squared away and you will be good to go. So take advantage of this checklist. And today we're going to be talking about things going on in the protections section, specifically, as I said, on intellectual property, protecting the things that we own. All right, I'll leave that up on the screen if it's helpful for folks for a second so you can see all of the things that are in the protections section. And while you're taking a look at that or jotting down some notes, I want to give a very important disclaimer, PSA, alerts, alerts, alerts everywhere, breaking news. I am a law school dropout. I am not a lawyer. Okay. And most importantly, I am not your lawyer. All right. So I am going to be sharing some general information about protecting yourself in business. And these are things that you can go online, you can get books, you can get classes and information on, but none of these things should substitute actual legal advice. Nothing that I say here should be interpreted as actual legal advice. Even if I take questions from folks that are in the bunker, please understand this is not legal advice. You are going to want to confirm anything that I share with you today with an attorney that you hire for your purposes before you take any actions in regards to your business. Okay. So I just want to make sure that I make that very, very clear. I am a law school dropout. It doesn't count. They still make you pay for it though. But yeah, anyway, that's another thing. Okay. All right. So please do keep that in mind. If you need a lawyer though, I can help you out with that. As a law school dropout, I've got some friends. And I'm really excited because I am going to be having one of my friends in the bunker for a bonus refuel session on Tuesday at 6 p.m. Eastern. So if you're watching this in live time, next week, Tuesday at 6 p.m. Eastern, my friend Taylor Tiemann Esquire, also known as the Legal Miga, who is a trademark and contract attorney, is based out on the West Coast, is going to be here in the bunker for a very special private Q&A. This is going to be an opportunity for you to talk to a lawyer about your specific situation. So if hiring an attorney is maybe not in the budget right now, or you don't know who you should go with because there's a million of them, then definitely make sure that you are in the bunker and tune into this session so you can get your questions answered for free. Okay. Get a chance to chat with a lawyer. This is such a great opportunity. If you're wondering how to get in the bunker, I will drop the link to that as well. Bless you. Down in the description so that you can get in. Joining the bunker is free for the first 7 days. So come on in, take a look around, get to know the space, utilize all the resources, and decide if it is right for you. I think you're going to decide to stick around, but you do get to join for free and check it out. And I hope to see all of you in Tuesday's session. All right. So, protections, intellectual property, the things that you create, the things that you make, the people that you work with and exchange things with are going to have a role in the ownership of the things that you have. And it might not be very obvious exactly who owns what and what you need to do in order to make sure that the world knows that you created something and that they can't use it. So I want to talk about three things, three tools that you can use that you want to be familiar with in terms of how to protect yourself and your intellectual property. And those are contracts, copyrights, and trademarks. Okay, contracts, copyrights, and trademarks. These different things, these different tools have different aspects to them, and they're appropriate in different circumstances. And I want to give you a general overview of when you might want to use any of these three tools to make sure that you are all good with all of the things that you created. And I'm going to start first with contracts. Because this is something that is a lot more flexible in the sense that a contract creates an agreement between you and another party that essentially is supposed to just sit there and hopefully really never be used. And the idea of the contract is, should there be a problem or should there be a question of who owns what belongs to who, your contract should detail that and explain that. And if somebody does something that is in violation of the ownership of that thing, like using something that actually belongs to you, then that contract is there to back you up if you decide to go and take action against that person to get them to stop using that thing, etc. Okay. So a contract, when we are doing things like tarot readings, Reiki sessions, etc., we don't really think about having our clients sign contracts. And I can totally understand that, right? Like I'm in the life, I'm in the world, right? So I know what it's like when you're trying to get clients, you're trying to get customers. The idea of making a potential tarot client sit and sign a 3-page document or something before they sit down for a 15-minute tarot reading seems like really weird and awkward, and probably feels like something that might drive business away and things like that. So I have noticed that most tarot readers and energy healers tend to not include a contract in the exchange of services that they are rendering. And I can totally understand why that is, but there are a couple of things that you want to keep in mind that might encourage you to start using contracts when working with people, or to just come up with like agreements for yourself. And in particular, I think that really comes up when we are talking about recording of sessions. This is something that I've seen folks do. We were just talking in the bunker about folks that are recording their meditation sessions, hypnosis sessions, energy sessions. Sometimes we might record our readings for our clients and share them with them. Or perhaps we are creating something custom for a client, like we're doing like an email report of an astrology reading or something like that. Who does that belong to? If you give a recording of a Reiki session to your client, can they now go and post it on their socials? Could they use it as a part of a class that they're teaching? Could they potentially take your astrology report and sell it on their newsletter? Um, could they make money off of it? Does it belong to you, even though you sent it to that person? What's the deal there? That can get really kind of fuzzy. And these are circumstances where I encourage you to create contracts. Okay. And when you create a contract, it doesn't have to be, a 20-page document that like gets notarized and like is all super complicated. It can be very simple contractual language that you can work into your booking system as a set of like terms and conditions, right? So if you've signed up for a cell phone plan or whatever, there's probably a little button that says, do you want to check off, the terms and conditions? Do you agree to these terms and conditions? And when you do that, you have effectively entered into a contractual agreement with whoever you said, yes, I accept your terms and conditions. So I encourage you, my readers, my energy healers, etc., to include terms and conditions on your booking sites in regard to any material that you share with somebody else. And because it is a contract that you are creating, you get to decide who owns what. All right. So the beauty of the contract is it's not between like you and the government or anything like that. It's between you and the person. And so you get to decide what the terms are, and then that person decides whether or not they agree to it. And ideally, they actually take the time to read the terms and conditions. But failure to read the terms and conditions does not typically absolve someone from abiding by them if they agreed to it. So if you're using a booking site, or if you're using some type of delivery software in order to send your reports to people or share videos with folks, I encourage you to include some type of language that indicates who you want to own those pieces of things that you're exchanging and what you are okay with them doing with those things that you are exchanging. So that if somebody goes and reposts something or reuses something, etc., it's really clear whether or not you have given them the okay to do that. And if they do something that violates those terms and conditions, now you have something in writing that you can say, hey, you agreed that you would not do that. I sent you this astrology report and you agreed by making this appointment or by checking off these terms and conditions that you would not use this anywhere else, that you would not reshare it without permission from me, that you would not monetize it, etc. And that's going to back you up, hopefully, to get that person to stop using that thing in a way that you did not intend. Okay. The thing about contracts, though, is that at the end of the day, if there is a serious issue, then they have to be argued over. The fact that a contract is in place doesn't automatically mean that you're in the clear. You would have to present that contract, perhaps in front of a judge, or et cetera, and say, this is what my contract says. These are what my terms and conditions say. They agreed to that, and therefore they cannot do this thing. And then that person has to agree. The deciding body, the court, the judge, the arbitrator, the mediator, what have you, has to say, yeah, that's what that says. Yep, this person agreed to it. Whether they read it or not is here or neither here nor there. And therefore, they have to stop doing this thing, or you can be compensated for this thing that they did, etc. All right. So a contract is good, but you might have to spend money or invest time or whatever to actually enforce that contract. But having it in place, having some terms and conditions that create a contractual agreement for someone to not use things that you have created in a way that you did not intend is going to back you up. Okay, it's going to back you up. Contracts between you and contractors is another one that spiritual practitioners sometimes don't think about. So, if you have ever done maybe a branding photo shoot to take pictures for your website or for your social media or something like that, maybe you had somebody follow you around while you were doing a festival or a fair to get some content for you. When it comes to intellectual property, ownership typically falls to the person that created the thing, which means when you contract somebody to design a logo for you or take photos of you, they are the creator of that thing. And so even though you paid them for their services, maybe you paid them for the product, that doesn't actually mean that you own it, which means that that person maintains the right to use it as they want, right? And you see this quite a bit with like logo designers or with photographers doing photo shoots where they will take photos for you or they will create a logo for you. But then they will turn around and use that same logo, those same photos to promote themselves, right? They'll make a portfolio of their work and they'll include that in there. And because they created it, they have the right to that. Okay. If you would prefer that that not happen, a contract can help you. An agreement can help you. There are agreements that you can make that essentially will transfer um, ownership over to you and say like you can't use this for your own purposes, or ultimately this belongs to me and I'm going to give you the okay to use it for your promotional purposes, but I'm not going to give you the okay to use it for any other reason, etc. The terms of the contract are, between the different parties, but we often don't think about that. You hire someone to make your logo, you hire someone to do a photo shoot for you, you buy the picture, you buy the photos, and you think, okay, well, these belong to me. Technically, they don't. They belong to the person that created it. So if you actually want to assume full ownership of those things, a contract between the parties can be executed to transfer the ownership over to you. Okay, so keep that in mind. Contracts are helpful for things we share with our customers, and contracts are helpful for things that we purchase from contractors. Now let's talk about copyright. Copyright is a way of protecting authorship, things that you have written. It's mostly for like written work, though it can also be for art, photography, etc. Because even though you're not necessarily writing words, you are the author of these things. So copyright protects authorship. And this is not a contract between you and another party. This is an agreement between you and the government, the US Copyright Office. And what you're doing when you apply for a copyright is basically saying, hey, I have written something, I have drawn something, I have designed something, and I want to make sure that no one else can go and copy this somewhere else without giving me credit, without getting my permission, without coming to me for an agreement. Copyright is automatic. When you author something, like I said, ownership automatically defaults to the person that actually created it. So if you wrote something, if you painted something, if you took a picture of something, you are the creator and therefore you have the copyright protection. The reason why you might decide to go the extra step of actually getting a copyright registration with the government is to give you the ability to sue someone in the event that they repurpose or repost, reuse your creation. Okay. So keep that in mind. You don't need to go and file a copyright registration for everything you create. The understanding is automatically the creator is the owner. But you don't have any ability to sue anybody or do anything if anybody were to rip you off. You would just have to basically go to them and be like, hey, that's not cool. Blast them on social media and be like, this person ripped me off or whatever. And when it comes to things that you perhaps have created but are not necessarily making a lot of money off of or anything like that, it might not be, that big of a deal. But when you create something that you are selling, like a course that you're selling, when you create something that is a major aspect of how your business functions in the world, like your business name or your logo design, and you've put a lot of energy and money into becoming known by that name, and then somebody comes along and basically wants to take advantage of like your popularity or your success by creating a name that's sort of similar or having a logo that kind of looks like yours, then that could be a huge problem because that could actually take business away from you. That could actually take money out of your pocket. And if you don't have a copyright, you really don't have as much ability to go into court and say, give me my money back. Like, that belongs to me. And any money that you have made off of the thing that I created is money that was supposed to come to me. So a copyright allows you to actually take legal action if somebody does that. So you don't need copyrights for everything you do, your social media captions or some reel that you made or what have you. But if there's something that you have written, like a book, maybe you're self-publishing something, or maybe you're selling your blog posts through something like Substack or what have you, then you want to make sure that you have copyright over the things that you created, so that if somebody else tries to piggyback off of your success and make money off of those things, you can actually take legal action to, one, stop them, and two, potentially get compensated for the impact that they had on your business, or the money that they made off of your work. Okay. So don't need to have a copyright for everything. Gives you the ability to actually take legal action. And I think most folks would recommend that you do it for anything that you are generating revenue from. Okay. That's a major aspect of your business. Next, we have, by the way, filing a copyright is like $45 or $50, and you would be going to the U.S. Copyright Office online. This is a process. I have copywritten things before. It is not a complicated process. It is not necessary to pay anybody to help you with your copyright. No offense. I'm sorry. I hope I'm not, I'm sure there's people out there who will do it for you for a fee and things. And I would say if you have a lot of material, if you are publishing something internationally, it's got a lot of range, and it's a huge aspect of how you make money, things like that, then you might want to enlist the services of an attorney or get some further advisement, etc. But for something basic like a course that you created that you want to sell on your stand store or something like that, you can go to the U.S. Copyright Office and file online, and it's like $45. You can also file in person, I think, but it costs more. I don't know why you would do it that way. But you might have your reasons, but you can file online for about $45. It's not a difficult process. You're basically going to fill out a form. You're going to put in the ownership information. So that's either going to be you or your business, and who owns this. And then you're going to give a copy of what that is, so that that can be put on file, so that it's clear what it is you actually created. So if somebody were to copy it, you can say, this is the thing that I got copywritten, and you are using this thing. So you're going to need to submit a copy of whatever it is that you are copywriting. All right. And then finally, we have trademark. Trademark, like a copyright, is not an agreement between parties. It is an agreement between you and the government. It is a way of establishing ownership on like the federal level. And you are saying to the government, hey, I am using this mark as a way of representing my business in some capacity. So we don't trademark things that we wrote. We don't trademark poems. We don't trademark books. We don't trademark photographs, etc. That all falls into the world of copyright. Trademarks are for protecting marks, which is like a legal way of describing the things that represent your business itself. So this can include your business name, your business logo. This can include taglines that you might use to market your business. Okay, all of this falls under your trademark category. And when you are considering whether or not to trademark something, I think one of the biggest considerations is that these things actually represent your business. So in a way, they are the business. And so it's best, I think, to err on the side of caution and trademark anything that feels like it represents your business. The name of your membership group, right? We are in the bunker right now. I need to trademark that. Okay. Your membership groups, etc. These are all things that represent what your business is in the world. If somebody sees, the Apple logo, no one has to say this is Apple. That picture represents that business. And so Apple is going to want to trademark that so that somebody else can't use that Apple to represent their business. That could cause confusion. That could cause people that were intending to buy an Apple product to go to this other business and accidentally buy that product. And that could hurt Apple's sales and bottom line. Your tagline might become really popular. It might be the thing that people start to recognize you for, and they know your business by that. One really popular one in like pop culture right now, we're probably all familiar with Tabitha Brown, and I believe she has a popular tagline where she basically says, but that's my business or something like that. Right. And people began to know her for that line. So even if you don't know who she is, even if you don't know what she sells or what she makes or what her story is or what her business is all about, you might be familiar with that tagline because she's been saying it in all of her videos and all of her content for the last however many years. So she has trademarked that saying, because if somebody else came along and started using that saying, it could confuse people and send people away from her and towards that individual. If someone were to Google it and someone else came up, that could hurt her bottom line. So she has trademarked that popular phrase so that other people can't use it and take advantage of the fact that she has built it up over all of these many years. Okay. So that is what a trademark covers. Unlike copyright, it needs to be established. So with copyright, once you author something, once you create something, the assumption is you are the owner. Copyright will just allow you to then take legal action if someone reuses your stuff. Trademark is not the case. You do not automatically own your business marks just because you created them or just because you're using them. Even if you've been using them for years, okay? You could have been using your business logo, for example, for 20 years. You don't own that mark. Now, if somebody came along 20 years later and copied it and tried to use it in the same industry, you would have more of a case on your behalf, but you would have to go and fight that. You know what I'm saying? And fight the person's attempt. If that person came along and tried to trademark it themselves, you'd have to go and fight them and say, no, USPTO, don't give this person a trademark. I've been using this mark for 20 years. And blah, 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 blah. But obviously that is a legal battle. You're going to need lawyers. It's a whole to do, could cost you a lot of money and a lot of time. So we don't want to put ourselves in that position. We want to trademark, protect our marks, the symbols and phrases that represent our business, because it does not automatically get established upon creation. You have to file for it. You file for a trademark with the USPTO, the United States Patent and Trademark Office. And you would want to start by searching their database. They have a free database that you search that will pull up all of the trademarks that are filed with them. And you're going to want to run a search and look to see if anybody else has already trademarked a word, a phrase, name, a logo, catchphrase, etc. And once you're in the clear, you see that that is not the case, then you would go and file. Filing a trademark is more complicated. Full disclosure, I have not done it by myself. So I can't really speak to the ease of the process of doing it by yourself. This is a situation where you might want to bring an attorney. So definitely make sure you're in the bunker next week so you can talk to Taylor about her services and maybe reaching out to her firm for some help. But you can technically file it for yourself. You're not required to hire an attorney to do it. You can go to the USPTO website and file the application for yourself. It used to be about $250. They went up January 18th, 2025, I believe, and are now $350 to file. Okay. But that's the thing. The thing to know about filing a trademark is if your application is not accepted, the filing fee is non-refundable. Okay, non-refundable. You just have to try again. So this is one of the reasons why people decide to hire an attorney to do it for them. The attorney will run all of the proper searches. They will make sure that nobody else is using it. They will file it on your behalf, and they will make sure that you have all the proper paperwork and, you know, all of the things that you need to make sure that you truly properly own that mark. But a trademark attorney will also protect that mark for you. Meaning, if somebody comes along and does try to copy your name or does make a logo that's really similar or a catchphrase that's really similar, your trademark attorney will then go and write perhaps a cease and desist letter and send it out to that person. They might also monitor for you. Like if you have the attorney on retainer, you're paying them in an ongoing fashion. They might monitor for you, meaning that they'll be running periodic checks to see if anybody is out there coming up with anything similar, and on your behalf tell them, whoops, you cannot do that. I believe that's what happened with me when I had like a tea that I made. It's more of a copyright issue, but I think that person's attorney was like just scanning because I don't know how I came across their radar, but they were like, hey, we saw your tea, super cute, but you actually can't call it that. And I was like, oh, my bad. I didn't know, I'm new at this. We're like, no problem, just change it. And I was like, got you. But I had to redo all of my labels. I had to change my listings on my websites and all of that stuff. So it was work. And you might want to just not run into those problems by having an attorney double check that you can use something, and then also make sure that other people are not coming along and trying to copy you. Okay. I want to share with all of my bunker witches a really, really, really helpful resource. I am a partner with Taylor Brands. Taylor Brands is a platform that helps you with business formation. They're pretty much a one-stop shop dashboard for all of the things that you would like to do to start your business, form your business, protect your business, etc. And on Taylor Brands, you are going to find contract templates. You're going to find copyright and trademark applications and assistance, and they have a dedicated line of experts that you can reach out to so that you can call somebody and actually talk to someone about your specific needs and assist you with the process of protecting your intellectual property. So I'm a fan of Taylor Brands. For my bunker witches, I posted them in the practical stuff section of the feed, and you can take advantage of that. For everybody watching on YouTube, I'll drop it down and pin it in the comments. You can use my link and get set up on Taylor Brands for assistance with all of this. Okay. Beyond that, I want to remind everybody that next week, Tuesday, in the bunker, we are having a special bonus refuel session with Taylor Tiemann, aka the Legal Miga. We are going to have a contracts and trademark attorney in the building to answer your specific questions. This will not be aired on YouTube. It will not be open to the public. You have to be in the bunker in order to take advantage of the opportunity to talk with a lawyer about your intellectual property questions. So I definitely want you to be in the building. The link to the bunker will be down in the comments, and you can join us for free for the first 7 days. So make sure to get in and be a part of it. Next week, for our regular scheduled weekly refuel session, Fridays at 12 noon, we're going to be talking about another important aspect of protecting you and your business, and that is going to be insurance. You might not have thought of yourself as a tarot reader, as a Reiki healer, as needing insurance, but I got to tell you, it's a very important thing to consider for yourself. So, we're going to talk about insurance. We're going to talk about waivers and liability, things that you could be responsible for, right? If you tell somebody in a tarot reading that, yes, in fact, she is cheating on you, and then there's something that happens as a result of that, are you on the hook? Is the tarot reader responsible for that? We're going to talk about that, and we're going to talk about how to protect yourself from being held responsible or being blamed for things that happen as a result of your services, the use of your products, etc. So definitely get into the bunker ASAP, because next week is going to be a really good one. All right. All right, witches. Thank you so much for tuning in to this weekly refuel session, all on trademarks, copyrights, contracts. Remember, you don't own shit. Okay. So make sure that you take the steps to provide ownership to everything that you create. And I will see you all in the next one. I'm going to now hop into the bunker to take any questions from the witches. So just another perk to being in the bunker. So definitely consider joining us there. But if you are on YouTube, you can drop your questions down below in the comments, and I'll try to get back to you as best I can as well. All right, everybody, have a great rest of the day. Thanks so much for being here. I always say this at the end of filming my podcast, but I feel like I might say this at the end of these refuel sessions too, because if you don't know, when you know better, you witch better. They go together. All right. See you all later. Have a beautiful rest of the day, and blessed be. Bye.